We are live and on the record.
Thank you very much. We are here for a single hearing, and it's 21J34 Forest Hills Housing Co-op Inc. Versus DIM. Council, you may be wondering how we're going to proceed from here. I typically handle these hearings in similar fashion to a Superior Court hearing, meaning there's no clock. That obviously doesn't mean that you can go on forever. You'll each have at least a couple opportunities to speak. I'm actually going to start with Mr. Turk. But before I do that, I find it useful to sort of lay out some of my current thinking about the matter, because that helps focus the parties in terms of the issues I see and what is bothering me. I want to start with by just pointing to the context of this hearing, namely that it arises on a preliminary injunction. So this is not the usual eviction action done through summary process. So obviously we turn to the four-pronged test on a PI. In this case, the plaintiffs are seeking, unless I'm missing something, the ultimate relief on a preliminary injunction. And there are certainly cases that say that that is not per se prohibited. On the other hand, it is relatively rare, and it affects the burden in terms of how the four prongs are analyzed. Or to put it in lay terms, if you're going to get the ultimate relief on a PI, you better have a damn airtight case on the merits. Now, when the plaintiff filed this action, I think we probably can all agree that it seems to have believed that it had an airtight case on the merits, thinking that the defendant was in the property, in the apartment, I should say, only as the approved caregiver, in which case I think we probably can all agree that that's their only claim. Then a PI might well have been appropriate. But as everyone knows, at the point that Ms. Dim answered, she revealed that she had been married to the approved tenant for, in fact, several years, and had been living in the apartment for a while, not just as an approved caregiver, but as Mr. Ume's wife. Unless I'm missing something, in the preliminary injunction papers, the plaintiff didn't really address this fact, but it did come up at the hearing. Now, keep in mind that given the both the interlocutory nature of this and the emergency nature of this, I don't have a record of the hearing. I don't know if it was recorded. I'm assuming it was on Zoom. I don't know if witnesses were sworn. I don't know if there's a record that's available. I obviously don't have a transcript. So I'm going in great part on what the two of you represent to me happened at the hearing, and what the judge said occurred. And the judge makes mention of the fact that one of the plaintiff's witnesses, it may have, for all I know, been the only witness, testified along the lines that even a wife has to be put on the lease, and therefore her status as the wife by itself is irrelevant. And the judge appears to have accepted that proposition, I would say proposition of law, and because he says very little about the marriage in his ruling. So he treats this case like an easy case that is she wasn't on the lease at the point that Mr. Ume died, and really that's the end of it. Frankly, I'm having a hard time seeing it as being that clear. Part of it is when I look at the lease, which is one of the few things in the record, and I'm assuming, unless you tell me otherwise, that it was before the judge. It's, first of all, I should say it's a rather old lease. I suspect a modern lease would look quite different, but it does say that when our family expands by, for example, marriage, that there is supposed to be notice to the landlord, in this case, the Forest Hills. As best I can tell, there is a dispute of fact on whether notice was provided, and the judge does not appear to have resolved that dispute of fact, feeling that he didn't need to. But putting aside whether there's a dispute of fact, the lease does not seem to address the separate issues of whether or not, in this case, a wife would need approval before she moved in on that basis. To the contrary, it seems to draw a contrast between someone getting married and somebody and a third party stranger, if you will, being added, where it's clear they do have to get pre-approval. Moreover, I don't see anything in the lease, and perhaps I read it too quickly, but I don't see anything there that says that she had to get added to the lease, nor do I see anything in the lease that even talks about the process through which someone in her position would be added to the lease. I'm assuming, and I'm about to turn the floor over to Mr. Turk, I'm assuming that there is a process. I know in the housing authority context, there are all sorts of processes for doing that. I'm unclear what the process is here, but I don't know what the process is. And if there's a possibility that she could have been added to the lease while Mr. Ume was still alive, I'm not sure it's as cut and dried as Forest Hills thinks all this is. And let me just add a couple things before I turn the floor over. I don't see, frankly, either side addressing the cooperative nature of the arrangement here. I don't know how typical that is in this context or not, but it's new to me, where the tenant had a legal interest in the shares of the cooperative. I did not find any clear terms in the lease in terms of what happens when the leaseholder dies. Shares in a co-op, I have to assume, are property interests, and unless they escheat, if you will, directly to the co-op upon death, I would think that, for example, a wife might inherit them. And whether those have any play in this debate, I have no idea. There is a suggestion in some of the papers, and perhaps even in the judge's ruling, that there's a whole federal overlay to how this is supposed to work. And that's frankly completely unclear to me, where from these papers, I don't even know if this is a Section 8 situation or something different. I don't know what federal regulations apply, I'm not sure sitting here today if they did apply, how they would apply in the specific context of the preliminary injunction hearing, where I don't see the regulations incorporated in the lease, which is the at least one of the binding documents that one would think is controlling here. And finally, on that point, I would have to assume if the regulations are anything like, for example, the Section 8 regulations, they also go into some detail about appeal rights and one's ability, if one thinks they should be added to a lease, to challenge a denial of that right. Finally, turning to the other prongs of the test, the judge appears to have accepted the plaintiff's contention that it would suffer significant irreparable harm if it were not granted the injunction. I am frankly having a hard time seeing that. I understand the argument that from the plaintiff's perspective, people on the wait list should be living in the apartment and not Ms. Dim. That would seem to go to the public interest prong, not the harm to the plaintiff prong. In any event, that would also is also somewhat tied to the merits, namely the stronger the plaintiff's argument on the merits, the stronger its public interest argument that she shouldn't be there, someone else should be. But on the specific harm to the plaintiff, I know Forest Hills has argued that trespass is a per se cause of irreparable harm. On the other hand, Forest Hills, tell me if I'm wrong, has no interest in occupying the apartment itself. It will be occupied by a third party in any event. The question is Ms. Dim or someone off the wait list. And then with respect to the harm to Ms. Dim, I'm wondering why that harm is not frankly self-evident to the extent she is evicted from the apartment. I understand there's a claim that she is not living there, at least for a while was not living there. And we can explore that in a bit. But I've gone on far longer than I thought I would. You know where my concerns are, and I will now turn it first over to Mr. Turk.
Thank you, Your Honor, and hopefully I noted all of your areas of concern, and I'm sure you'll let me know if I miss any. I guess to jump around a little bit, just to answer your question about the co-op overlay here, this is a limited equity co-op. It's not unusual in federal subsidized housing that was created back in this era that the HUD was encouraging properties to become cooperative so that owners would also have or members would also have an ownership interest in the properties. So this property is a cooperative. It is also project-based Section 8 housing also. So as far as the co-op goes, Your Honor, the defendant or the Mr. Ume owns a share. Upon his passing, that share would pass to his heirs, whoever that might be. He has family members who have asserted an interest in that, but whoever inherits that, the value of that share will get paid someday from the share value. But that's a separate relationship from the tenancy. He maintained an interest as a shareholder and is valued to that share of stock, but his tenancy rights are completely separate from that. Along with his ownership of that share does come the right to live in this unit, but it's a separate interest. So
no. Can I just stop you there? Because you said two things that seem inconsistent. you said what comes with the share is a right to live in the unit, but they're separate. Which one is it?
You have to, so there's I think the case is 1010 Mass Avenue is the case where the court said that you have two different interests. You have a shareholder interest, which is like any other shareholder of a corporation. You own a share of stock. You can sell that share of stock under the limitations there for a set amount. In this case, because it's a limited equity cooperative, there's a maximum share value. And that's controlled by bylaws and corporate documents. So he has that interest. His tenancy is controlled by the occupancy agreement and the regulations from HUD dealing with his occupancy. So they're two separate hats he wore. Shareholder, and his share will get dealt with under the cooperative bylaws, and tenant, which is controlled by his occupancy agreement and the program with which he participated, being the project-based Section 8 program. So who inherits the value of that share will be determined in the future if and when that share is sold.
Do you have a site handy for the project-based Section 8 regulations?
I will refer you to the HUD handbook regulations, which I think actually do speak directly to the live-in aid issue. It's the HUD handbook. It's 450.3 revision 1 is the current HUD handbook, which I actually would refer your honor to as I argue regarding the rights of a live-in aid, because the HUD handbook specifically identifies that.
Okay, but I don't think anyone is contesting that she has no right to stay there as a live-in aid at this point. So what would be helpful is if there are HUD regulations that address the issue of tenants getting married or people getting added to the family members getting added to the tenancy, those would be helpful.
I'm happy to provide the citations for that, but I guess the point I would make, your honors, no one is contesting that Mr. Ume could have added his spouse as a co-tenant. He absolutely could have. The problem is, and as was testified to, and as we provided the record, the documents for it, he elected not to do that. And he signed each year a HUD 50059 under the pains and penalties of perjury, and we provided them to your honor. They're Exhibit A.
Now, let me, before we go on, I know what documents you're referring to. Were those before the trial court judge?
Your honor, the manager testified to what was in them, but because these are not the defendant's documents, the dilemma that we have is we can't put them into a public record because they are not Ms. Dim's documents. They refer to private confidential information of the tenant, which is not Ms. Dim. But the manager testified to the fact that every year Mr. Ume executed the forms where he certified under the pains and penalties of perjury that this was his live-in aid. And that is his right. He can designate a person as his live-in aid. And as a result, and every year he certified that. There's a letter that is in the record where management confirmed that this person was added as a live-in aid. And based on that election, she only gains the status of live-in aid. They absolutely could have added her to the lease. But the result of that would have been her income would have then been included in the determination of their rent.
What is the process for adding someone to the lease?
You simply come into the office and you request to add them to the lease. They are then screened and added to the lease and added onto the 50059 form, which is then filed with HUD, so that HUD then accepts that that person is an occupant, a household member not a live-in aide, that person then has to provide income verification and asset in verification to confirm that they qualify under the program. In this case, Your Honor, which is not an unusual case, and as you see from the cases we've cited in our briefs, live-in aides all the time are added to leases. People make that election and receive the benefit of that, which is your rent does not go up. But the result of that is you don't then have survivorship rights. And that's where I would point you to the HUD regulations, which specifically say, and again, it's on page 3.3-10 of the HUD handbook. It says the live-in aide may not qualify for continued occupancy as a remaining family member. So that's the ramification of it. If you make the election to add them as a live-in aide, the result is that person doesn't have continued occupancy rights upon death. And that's the election they made here. And every year they verified under oath, under pains of perjury, that she was the live-in aide. And on every form they signed, she signed as a live-in aide, not as a household member. So it's uncontested. They could have easily added her as a household member.
Now,
They didn't.
as I understand it, Ms. Dim is asserting that she and her husband went to the office and he introduced her as his wife, raising a dispute of fact on that point that I don't recall the judge having addressed or resolved. If one can certainly imagine a situation where that was true, and for whatever sets of reasons, whoever was working in the office allowed her to sign on as a live-in aide. I don't doubt that there is some strength to the arguments you're making. I'm having a hard time seeing them as so clear that you can get a PI resolving the entire case, especially when there are open factual disputes that were never resolved.
But the problem is, Your Honor, there is no open factual dispute because they signed under the pains and penalties of perjury, the 50059s. And you can't then go back and say, wait, I actually wanted to be added as a household member when you sign this verification to the federal government that no, they're a live-in aide. A live-in aide can be a spouse. A live-in aide can be a family member if you make that election. But you make that election to HUD. You represent it to HUD, and then you can't go back later and say, wait, I want to change my mind now. I don't want the burden of that election, which is what's absolutely happened here. Even if, let's assume that's true. Let's assume it's true that they came in and said, hi, this is my spouse. She's going to be living with me. When you sign the 50059 and you confirm that the person's a live-in aide, that's their status. There is no status with HUD or landlord-tenant law of spouse. You're either a household member or you're not.
But is there anything in the lease, in the HUD forms, that say not only can a live-in aide not stay on, but that by signing this form, you're waiving any right to be added to the lease as, for example, a spouse?
Yes, Your Honor. Again, the HUD handbook makes clear, if you are designated as a live-in aide, you do not create any survivorship rights.
No, I understand that, but that's not what I'm saying. I'm saying that if she could have gotten on as a wife, was she on notice that by signing that she was a live-in aide and couldn't stay on in that capacity, knowingly waiving her right to get on the lease? You're kind of assuming that to be true, and I'm trying to test that and see whether or not there's anything in the forms that she signed that makes it clear, not just that she was waiving her right to stay on as a live-in companion, whatever the term is,
Live-in aid.
Live-in aid, but that, she was thereby foregoing her ability and right to be put on the lease.
Yes, Your Honor. The live-in care attendant, addendum that she signed specifically says the live-in aid will only meet the criteria for occupancy as long as the resident needs supportive services and remains in residence. The live-in aid has no right to occupancy, even if the live-in aid is a relative of the resident and may not qualify for continued occupancy as a remaining family member. And again, Your Honor, Mr. Dim, up to the day he passed, I'm sorry, Mr. Ume, up until the day he passed away, could have come in and said, I want to change her status to tenant. And then her income would have been verified and she would have qualified. He didn't do that. I mean, we have a case, Your Honor, very similar, where the tenant actually had done that, but HUD had not approved the change in status and the person died and HUD said, sorry, you didn't do it in time. The paperwork was in process, but until HUD changes the designation and approves that, you are a live-in aid, even if you are a family member or a spouse. And again, there's a ramification to that election.
Okay, can you say the language you about a minute ago read to me about notwithstanding being a family member or words to that effect, is the language you just read from the form that are in your materials?
Yes.
And did the testimony from the witness, since these forms you're now telling me were not before the judge, did the testimony from the witness specifically state that this was in the form?
It did, Your Honor. She testified that the tenant had signed the live-in aid agreements. There was a lot of cross-examination about what was done to do the background check of this person, but the manager was absolutely clear that this person was only a live-in aid. The 5059s each designated them as L for live-in aid, and she signed the documentation confirming she was only a live-in aid. Now, whether she understood that or not, I can't say, but when you sign these agreements and the tenant makes representations to HUD, that's binding, and you can't go back and change it afterwards.
What is your case support for that being binding?
I'm sorry, Your Honor?
What is your case support for that being binding, that a tenant or a third party would be stopped by the representations on the form? I'm not questioning it. I just want to know what.
If that's an issue, I can find case law, but they're signed under the pains and penalties of perjury. The 509 specifically says, again, under U.S. Code, Title 31, Section 3729, false claims provides for a civil penalty of not less than $5,000 and more than $10,000, plus 3 times the amount of damage for any person who knowingly presents or causes to be presented any false or fraudulent claim, or who knowingly makes or causes to be used a false record or statement, or conspires to defraud the government by getting a false or fraudulent claim allowed or paid. And on that form that, again, Ms. Dim signs, she's designated live-in aid. And again, the result of that is fraud, because for all these years that she says she's been living there, which apparently dated back before she even was added as a live-in aid, they didn't report her income. That's income fraud. And that's exactly what you can't do to HUD and the landlord. You have to properly report all household members and all household income. They reported her and certified it as a live-in aid on every document, every recertification, every year.
Okay, I want to switch sides in a bit, but could you quickly address the other prongs?
I can, Your Honor. And again, I do want to go, I guess Your Honor had a question regarding the irreparable harm here. And I think, first of all, the case law is clear that this is a trespass. She's not a tenant. She's a live-in aide. No remaining rights when the tenant passed away. She's a trespasser, and I think the cases that we cite are clear that trespass is per se irreparable harm. This is no different than if the cases we have where someone dies and we find someone just living in there. They're living there. They have physical possession, but they don't have legal possession. Any claim to legal possession, we don't have to prove any harm, or we would never be able to prove harm on a trespass. If you're out living on my farm and you're just trespassing there, and I tell you to leave, I don't need my farm in the winter, but you're just living on my farm. I don't need my farm. I have no real actual harm, but you're living on my property illegally. Or if you break into my vacation home my summer home in the winter, I'm not using it till the summer, still a trespass. I don't have to show I need that property. I think it'd be a dangerous precedent to say that a trespasser can hold over in subsidized housing, and we have to show some actual harm. As far as the actual harm beyond that, Your Honor, first of all, I will note that HUD has stopped payment on this unit. The rent is $1,800 a month. It is the rent for this unit. HUD stopped subsidy because they don't recognize Ms. Dim as having any legal right to this unit.
Is that in the record?
It's in the record that the HUD had stopped paying. We did not put anything in regarding how much, because again, Your Honor, at that point we're not looking for a bond order or anything else. But I could provide an affidavit that HUD has ceased payment, and it's $1,800.
No, but is it in? Did the fact that HUD stopped payment, is that in the record?
The fact that HUD stopped subsidy, I believe, is. How much? No, Your Honor. Because again, I don't think it's necessarily relevant, but because again, I think it goes to per se irreparable harm. I think the other irreparable harm here, Your Honor, that you do have to take into account, I do think it is irreparable harm, is, what's happening here is you have somebody who made an election to be a live-in aide, received the benefit of that, and there are people that we have an obligation to house that have been waiting 4 years for this housing. And if this person is allowed to simply remain in this unit for the pendency of this appeal, which the court knows will take likely years, that person is denied housing for all this time that they've been waiting properly on the waiting list. I would also suggest, Your Honor, that irreparable harm to my client is that we're outside of our contract with HUD. HUD only allows us to allow people to occupy these apartments that have been screened, that have gone on the waiting list, that have followed the rules to live in this housing. She has not done that. She has jumped the waiting list. She's not waited for 4 years because of the election that she made. And I think also, again, in balancing the harm, you have to look at the merits here. I would suggest to Your Honor that there is no claim that they have their claim is that, well, she's married, it's her spouse. But again, that's not a tenancy right. There is no claim here. The uncontroverted evidence is she's a live-in aide. And that's what's been always a live-in aide. And a live-in aide is a trespasser when the tenant passes away.
But if instead of, in your words, electing to be a live-in caregiver, she had been added to the lease, then under, as I understand it, HUD's regulations, she could have effectively jumped the line of the waiting list, correct?
But yes, Your Honor, but it would not have been her election. She has no rights. It would have been the tenant's election. She has no rights here. She's a live-in aide. Whether she was married to him, was the son, the daughter, whoever she could have been. Any of the people can be a live-in aide if you certify, I need help, I need a live-in aide. I want this person to be my live-in aide, not my co-tenant, which again.
But under the lease, unless I'm missing a provision, she could have moved in without pre-approval.
No, Your Honor, she could have done nothing. He could have asked to add her to the lease.
No, but there's nothing in the lease that says she has to be added to the lease before she moves in. He is supposed to tell Forest Hills that she's moving in. I don't see any pre-approval. I don't see any requirement that should be added to the lease.
Your Honor, I can go back and look at the lease, but I'm relatively sure that you have to request a change in.
Well, if you find that, please tell me, because I didn't see it.
Your Honor, I'm happy to look while my brother's arguing, but I believe the lease does provide that only the people named on the lease are able to occupy the premises.
Okay, just one last point on your comment that appeal will take years. The only appeal in question now is a Section 118, paragraph 2 appeal of the issuance of the PI. If, and this is complete hypothetical, if I were to continue the stay of the PI, the net practical result is, I suspect, regardless of whether or not the pending appeal is prosecuted, the merits would be addressed in the housing court with perhaps a little more analysis than was done up till this point. But let me turn to Mr. Odenukwe. I apologize if I
Yes, you nailed it, Judge.
almost got it right.
Yes, Judge. The hearing on December 21st before the lower court judge, because today, my brother here, they sent a whole lot of documents to this court. There were only 3 documents introduced to the lower court judge. And one is the old lease from 2002, which I read, and you are correct. There was no mention or any provision regarding the situation we have here, whether the tenant, Mr. Ume, should get a pre-approval for adding a family member. So many things were silent on that lease. I read it and I brought it before the lower court judge. Second exhibit was the 2018 unsigned letter. They're unauthorized, unsigned. That was written by one Lisa Cassiano, who, by the way, did not testify at the hearing. And the third exhibit, Judge, was the October 2020 notice to vacate the premises sent to the defendant. That's all that was before the lower court judge. And based on these 3 documents, the only witness the plaintiff introduced was an employee who was not there when the 2002 lease was signed, was not there when Mr. Ume introduced the defendant as his spouse. She testified to that she was told. Was not there when any of those living documents that they talked about were signed. All they gave the local judge was talk, with no documentation, Judge. And I did point it out to the lower court. On December 18th, I sent a request for documents, which I believe was on the record here and in the lower court. And I asked specifically for documents that would have cleared or at least given some more insight into the what we have here today. Any documents signed by Mr. Ume or introduced by Mr. Ume to the plaintiff, any document signed by the defendant sent to the plaintiff, and so many other things that I requested, they did not provide anything. They did not produce anything. And I did raise that before the lower court judge, that all we have here on December 21 during the hearing is just talk with no evidence. They classified my client as a trespasser, as a living aide. I said, okay, where's the evidence? Because it doesn't make sense. Mr. Ume, there was no evidence introduced at the lower court that Mr. Ume is qualified for a living aide. No evidence that he was disabled or is elderly, none of that. I specifically asked their witness, is there any documentation that you have to show that the defendant in writing, or Mr. Ome in writing, introduced the defendant as a living aide. She said, no, no, zero, no documentation. So I said, so I just have to believe your word for it. So there was zero documentation. And my brother just said incorrectly a few minutes ago that their witness read the line on the, I think he called it the 50059 hot forms about the language about living aids. She didn't read that. She didn't. She just claimed that my client, sorry, that Mr. Ume signed the verification forms. She didn't say what was in there. I know I asked her specifically, do you have that document here with you today? She said no. So my argument, Judge, this afternoon is based on what was before the lower court judge on December 21. The plaintiff did not meet their burden for an injunctive relief. They did not produce any evidence. All they have is what they say. Mr. Ume and the defendant, my client, they lived in the same building, in the same apartment, one bedroom apartment, Judge, since 2016. The judge in her, the lower court judge in her written findings wrote that she found my client's testimony credible. Part of what my client said was that she went with Mr. May in 2016 and Mr. May introduced her as the wife. 2, she testified that she now worked as a living aide. Another fact is that in 20, even though that was not presented as an exhibit in the lower court, but my client and the Mr. Ume filed in 2016, which I have here, which my brother never requested, filed in 2016 a federal tax return as filing jointly, married filing jointly. In 2017, filed for both federal and state, married filing jointly. 2017, 2018, 2019, those 4 consecutive years, both state and federal. They have a joint account as spouse, married. My understanding is because what the plaintiff is doing here is selective discovery. What they sent, I'm happy that they sent more information to this court, not to the lower court. What they sent here is just what they think they need to prove their case or to prevail in this case.
Okay,
My understanding is,
I want to break in here and ask a very basic question,
sure.
which is, am I right to assume that the hearing was recorded in some fashion?
Sorry, I didn't, can you repeat the question, Jeff?
What, am I right to assume that the hearing was recorded in some fashion? I'm getting
It was on the
head
record,
shake.
Your Honor. It was on the record.
I will assume so. It was just like, it was a Zoom hearing. So I will assume.
Zoom hearing.
Yes.
And by the way, were the witnesses sworn in?
Yes.
They were. Do either of you know if the audio recording is available?
When I went in person to get the what I filed with this court, I did not ask. I don't know. Based on the time, the expediency, I didn't ask for the recordings and stuff. But we can always find out, Judge.
Yeah, Your Honor, it's available on FTR, as are all trial court proceedings.
I was able to, through the good graces of one of our excellent clerks, to, in a different housing court matter, retrieve something from the FTR. So perhaps I can do so here, because there are frankly some basic questions in terms of what was before the trial court judge. And I think we probably need an answer to that. I am not above listening to recordings myself as opposed to forcing parties to get transcripts. So I can try to retrieve that. If in the interim, one of you happens to obtain an electronic recording of the transcript, feel free to pass it along in whatever useful format you can. In any event, I am sorry for interrupting you, but I wanted to get that down for now.
So they filed these consecutive tax returns. And it's my understanding, Judge, that the annual verifications, which is done every year for these hard subsidized apartments, includes income verification. And income verification typically includes your tax returns. Your tax returns or 1099, W2 forms, all that stuff. Part of my discovery request, because if the court, by the lower court granting the injunctive relief, the case is basically over, because the final result is that my client is thrown out, is gone, case ends without any evidence, without, all we have is hearsay evidence. That's my contention, because their witness, one, testified to what she was told. She was not present at any of the major events. She did not produce any documentation about the living aid. And in my brief to this court, I even lined out at least some of the requirements a living aid should present. At the lower court, Judge, I did ask the question of their single witness, how was the defendant vetted or verified to see her qualification as a living aid? The only answer, which you can see when you listen to the record, is that they did a criminal investigation on her. They called a report. That's it, nothing else. Do you have, as a witness, do you have a copy of any of those verifications? No. So based on the three exhibits that I listed that's on the record that they submitted to the lower court, Judge, they did not meet their burden, Judge. It is disputed that my client is a living aid. She said, she testified that she is not. And in our view, and even the lower court judge agreed that her testimony, she found it credible. The ex-spouse of Mr. Ume is deceased. The defendant knows, so the plaintiff knows that. At the lower court, Judge, at the lower court, my client testified that she was the one that was making the payments, submitting the payments, monthly payments to the plaintiff. She testified that they're current in the payments up till the date of that hearing, December 21st. So all the lower court judge had was just words from the plaintiff, nothing else to back it up. So based on those, my contention, Judge, is that they did not meet their burden. They classify as a trespasser. When I reviewed the tax returns, she didn't make. I don't think even if the plaintiff included her income, it would have made any difference. Her income is insignificant. But the fact is, one, the lease they introduced as an exhibit is silent, clearly silent on the Mr. Ume as to what he must do in a situation where, like in this case, he married a new wife. There is nothing on the lease that gives a firm requirement that Mr. Ume has to do A, B, C, D. None. Number two, our contention is that the plaintiff is on notice, because when Mr. Ume, according to the testimony of my client, went to the management and introduced my client as the spouse, the plaintiff is on notice. Not every tenant, or not every tenant is as sophisticated to know what they are supposed to do. So the lower court judge, based on the totality of the what was said, what's credibly said, documents submitted, they did not meet their burden of proof. And the 50059s that my brother keeps talking about, I have not, all I have, Judge, regarding whatever was submitted by Mr. May or my client is what they submitted to this court that I received a couple of days ago. Even though I asked for a bunch of other things that would have thrown more light as to where actually the facts are in this case. Another thing I need to point out too is that in their brief in this court, my brother did state that my client left the premise, the apartment. Judge, she left because she went to bury her husband. This was raised before the judge at the lower court. She called in today, and the court said that she have to watch it on YouTube. She's calling from her apartment at 189 Forest Hill Street in Boston. She's back. Her husband was buried earlier January, and she came back from the funeral. That's why she traveled. I have evidence of that if the court wants. I have when the body was shipped to Nigeria, where they are from, and her ticket going and coming back. So that's why she was not. And my brother here knew that because I mentioned it to the lower court judge that she's traveling to bury her husband. She's already back. Regarding the harms, one, like the court here noted, the plaintiff, it's not personally harmed. It is the so-called waiting list, which basically we're just taking the word for it again. By the way, there was no mention in the lower court that HUD stopped any payments. I'm hearing it for the first time today. So in terms of harms, the plaintiff here, in our view, is not harmed. It's a multi-million-dollar cooperative. They are talking about some tandem waiting list that we're not aware of. What's the harm to my client? The harm, one, is they classify her as a trespasser. That's disputable in the first place. Number two, even if let's just assume she's a trespasser, and let's assume that the plaintiff can prove that. The harm is that we are undergoing, this country, the world, undergoing something that has never happened probably for the past 100 years, the pandemic. In the interest of justice and fairness, my client just lost her husband that was just buried less than 30 days ago. To just evict her and say, okay, fine, goodbye, change the locks. When you balance the harms, Judge, I think in all fairness, it comes with the defendant's side. You know, the harm to the plaintiff is that the multi-million-dollar corporation, the plaintiff, is some unproven or some potential waitlisted potential tenant might wait longer. That's the harm. The harm to my client is that a middle-aged woman that just lost her husband is that she'll be homeless. That's when you balance those. I don't think we need the MIT or Harvard degree to figure out that where the harm weighs more on. So, unless you have other questions, I am asking the court here to stay the decision of the lower court, because when the record before the lower court is reviewed, we can see that the plaintiff did not meet his burden in getting an injunctive relief that ends the whole case without any discovery.
Counsel, I'm going to interrupt you.
Sure.
If, again, this is hypothetical, if I were to continue the stay of the preliminary injunction, is this a case, in your view, that is amenable to resolution on summary judgment? I have no idea what kind of summary judgment practice there is in housing court, but I still ask the question.
Well, one way I can answer it, Judge, is at least in the regular court, summary judgment is usually after discovery is complete. where both parties can see the strengths and weaknesses of their case. In this instance, I've not received any of the, I sent interrogatories and I sent requests for documents. Zero was responded to, nothing. I think I actually reached out to my brother here prior to filing this to see if you can work something out. And they flat out said no. So we are still open to some kind of resolution without further litigation, but I think that's the best I can answer your question. Unless...
Okay, well, I'm going to turn it back over to Mr. Turk for a brief response. Before I do that, I want to note two things. One is one way or another, I think I need to get a hold of this FTR recording. And two, should either party wish to submit additional briefing up to 10 pages, you can do so by midday on Wednesday. Unless you can in good faith tell me that any attachments were in fact before the judge, I don't want to see any more paper, be it affidavits or exhibits or anything else. But up to 10 pages of additional briefing is fine. Do not feel, if you feel like you've made your case, don't feel like you need to do something. But I'm willing to receive that material. Now, I'm going to turn it quickly back to Mr. Turk and to see what he has to say.
Again, I think the real issue, it's a legal issue before the court. It was the same legal issue before the trial court. And that is, what is the status of this defendant? And what counsel continues to argue and continues to raise is, well, it's a one-bedroom apartment. What did you think was happening? Well, they filed joint tax returns, right? But none of those are relevant to the fact of they seem to acknowledge her status was live-in aide. And it's uncontested that a live-in aide, and I will submit to you the federal regulations dealing with live-in aides. When you certify someone as a live-in aide, they do not create tenancy rights. And without a tenancy right, when the tenant passes away, you're no more than a guest, right?
Counsel, I am not at this very moment convinced, without having listened to the transcript, that these issues were adequately explored before the trial court judge. I mean, you come at this with this background of knowledge about what the regulations say and how people are supposed to think about this. But if if the documents that you say lay out all of this stuff so that the tenant can understand it, were not in fact submitted to the housing court, and if in fact the testimony of the witness was not specific enough to relay what that language said, there may or may not be enough here to raise your as matter of law arguments.
So, Your Honor, I would say that I agree. You need to listen. You would need to listen to the transcript, because the witness was very clear about what was signed and what was part of the record and what is in the file. She was very clear on that, and I'm happy to attempt to determine how we obtain the FTR record for Your Honor. And I guess at least, Your Honor, I guess you would perhaps remand back to the judge to hear further evidence. But the concern, Your Honor, is it is common practice, if not the usual practice, that when you have a trespass, if in fact the judge found that this was a live-in aide, heard evidence, and again, I don't believe the testimony even from the defendant was that she was anything other legally than a live-in aide, then I think we're entitled to an injunction, because the assertion that you have to show irreparable harm and the harm to her, again, by that argument, that is a dangerous precedent, that when you have, whether it's a live-in aide or a guest that overstays upon the death of a resident, or for that matter, any trespasser that remains, that you have to do a full trial and you have to go through discovery, and in a year or two we'll get a decision. would completely obfuscate the whole concept of a trespass, of how we deal with trespassers in order to remove them. We deal with trespassers every day in the housing court. People found in apartments that don't have tenancies, people that remain after somebody moves out, and the court consistently issues injunctions. In fact, again, in our briefs, we cite you all the different types of cases where somebody stays over upon the death of a resident or upon the vacating of a tenant, and the court issues injunctions barring them from the property. We don't do discovery. We don't have a year-long discovery method. I would suggest you're on a summary judgment in the housing court now. To answer your question, you may be aware the housing court is overwhelmed with cases based on the eviction moratorium. We are waiting 2 to 3 months to get a mediation date from the housing court, let alone a trial date or a hearing date in the Eastern Housing Court. I don't think there are any factual issues, but again, I think the transcript is clear on that. But again, I don't think, while we can feel bad for the defendant, which we do, unfortunately, if she was a live-in aide, as testified to at the hearing, I believe uncontested, she has the status of a trespasser. She's already had 4 months to be there in that status, and she's unable to remain.
Can I ask a question to test you on how common this way of viewing the case is? It's been a very long time since I was a tenant, but thinking back many decades ago, apartments were regularly turned over with people inviting new people in, the people who live there sending the check to the landlord is accepting the check. And there are generations of people living in Cambridge who've never met the landlord, but are happy to send the check. I have a hard time believing that in that scenario, a landlord could evict someone who's been living there for years, saying, well, we never agreed to accept your tenancy. You're a trespasser, and we're going to establish this on a preliminary injunction because you can't show us a lease that says you're allowed here lawfully.
But that's a completely different case, because you can create a tenancy by your conduct of paying rent in a non-subsidized housing. That creates a tenancy at will, if you pay rent and the landlord accepts it. This is a subsidized project-based HUD subsidy. You can't create a tenancy against the federal regulations. You can't just move into someone's apartment. In fact, again, if this court allows this, I can, in my subsidized apartment, move someone in as a live-in aide, move out the next day, and we will no longer have waiting lists for public housing. We will found a loophole around that. I move you in as a live-in aide, my rent doesn't change, I move out, despite what the HUD regulations say. I've now created a tenancy with this. All those people who follow the rules and stay on the waiting list, to forget about them, right? I got in. That's not how it works in public housing. You can't do it.
But I understand that, and I don't think anyone's saying that she could stay on in her capacity as live-in aide, where the person aided has died.
If I may.
And yeah, in any event, I'm going to turn it back once more, but especially since I'm.
And I just wanted to direct you to the provisions of the lease dealing with having to get written approval to add a household member, and that is paragraph 9, which does say in each case receiving prior written consent of the corporation to any change in the occupancy. And likewise, paragraph 11, Your Honor, which does specifically say that if you are a recipient of a subsidy fund, you are required to report and get written consent for any change in household, in family size. And that does then create a change in the rent. And again, in this case, there's no argument that any written consent of the corporation, the landlord, was ever obtained for a change in household size. And in fact, again, in the record at the trial court was the document where the landlord acknowledged that this person was being added as a live-in aide.
Okay, I think I understand the argument. And as I said, you can feel free to supplement your arguments in writing by Wednesday at noon. Very quickly.
Yes, Judge, a couple of things. Plaintiff keeps saying it's undisputed that defendant is a living aide. That's not true. It's disputed. My client testified that she's not a living aide. Mr. Ume is not here to testify as to what he submitted or did not submit to the plaintiff. My client testified that she was there when Mr. Ume brought her in and introduced herself as the spouse. They keep saying it's disputed. They are the ones saying my client is a living aide. They have not produced any documentation. The 5059 he's talking about, I believe, also includes information about income tax return verifications. So these are all disputable facts, disputable arguments.
Well, can I stop you there? Because
Yes,
I think the response we would hear from Mr. Turk, if he were allowed to respond, is something along the lines of whether she was a live-in aide is to a great extent a question of law. And if there was testimony that there was a request, and I just assume there was competent testimony of that there was a request that she be allowed there as a live-in aide, and that's in fact how she was allowed into the apartment, and that was her status. It doesn't matter if in fact she fit the job description of a live-in aide or even intended that. That's her legal status. And go ahead.
I got that. I got the point clearly. The fact is that on the case before the lower court judge, there was no credible evidence introduced by the plaintiff that that's the case. Because I recall very clearly asking their sole witness, since all they have is what you have in terms of documented exhibits, I asked the witness, do you have any documentation today that my client classified herself as a live-in aide, introduced herself as a live-in aide, or Mr. May introduced her as a live-in aide? She said, no. All we have is her saying that Mr. Ume signed a form saying it's a live-in aide.
You're starting to get into the specifics of what was said. I gotta listen to the recording.
Amar, do you want us to try to find the FTR for you, or I believe there is a way, I've had other judges do it, that you can actually just log in to the FTR. I think anyone can do it.
Thankfully, I have people to help me do that. So
I'm happy to speak to the clerk in the housing court to find the technical. I think you just need a password to do it.
No, I think we have our passwords.
Judge, again, even after the court reviews the recording of the lower court hearing, the plaintiff, the witness that testified is not the right. I mean, in my view, it's not the right witness. Oh, she testified to hearsay testimony. She was not the one that received the 5059 forms, or received the form that they alleged my client signed as a live-in aide. She was not the one that did any of that stuff.
No, I understand the argument. It's complicated by the fact that I believe there's case law that in a PI hearing, some degree of, for example, hearsay is allowed. So, I mean, part of the context of a PI allows some relaxation of the rules, which is one of the reasons why I think there's a relatively high burden there when one is seeking the ultimate relief. But I will consider these arguments. I will consider whatever else you give me on Wednesday. I'm assuming, unless you tell me otherwise, that neither side needs me to issue a stay of the contempt proceedings for the moment.
No, you're right. That has not been scheduled yet.
Yeah, I will, once I get the recording and any submittals on Wednesday, I intend to resolve the limited matter before me rather quickly. And I thank you both for your time, and the matter is submitted.
Thank you, Judge.
Thank you, Your